Good morning, everyone. Did Michelle leave? No, I think she's still there. Good morning, everyone. Can you hear me? Oh. I want to welcome everyone to the 2021 Conservatorship Association of Tennessee Conference. I want to thank all of our sponsors that we have. We have Serenity Pooled Special Needs Trust. We have Blue Cross Blue Shield of Tennessee and Care Right Centers, our sponsors. And throughout the day, I will display information about those individual companies. Up first, we have Judge Hagan, who's going to give the keynote address. And I believe I'm going to introduce him, so I will turn it over to you now.
Good morning, everyone. Thanks for joining us. As Amy said, our keynote today is going to be Judge Inslee Hagan, Jr. from General Sessions Court in Wilson County. He was appointed by the Wilson County Commission in November of 2018 to replace beloved longtime Judge John Gwynn, who retired. Judge Hagan took office January 1st of 2019. He is a Wilson County native, and he ran unopposed in August 2020 and will be running again soon. He is a graduate of NTSU and the University of Memphis School of Law. And Judge Hagan practiced law with his late father, Tony, and his wife, Andrea, prior to taking the bench. His grandfather, Willard Buck Hagan, was a circuit judge in the 60s, 70s, and 80s. And Judge Hagan has been quoted as saying, "I saw how he treated people and thought, this is something I want to do one day." Judge Hagan, thank you for carrying on your grandfather's legacy and for creating your own. Judge Hagan's court in Wilson County General Sessions hears domestic relations, juvenile paternity, custody, probate, orders of protection, and mental health cases. He's very involved in his community, including the Lebanon First United Methodist Church, Lebanon Noon Rotary Club, Lebanon Rotary Foundation, and Senior Citizens Awareness Network. He lives in Lebanon with his wife and 3 children. Please help me welcome Judge Inslee Hagan.
Ms. Lee, thank you very much. It's my pleasure to join everyone, and quite frankly, I'm honored to have this opportunity to speak with you all. I have never been a keynote speaker. I've presented at several different CLEs and did so last week with several of our probate judges, Chancellor Oliver, Judge Kennedy, Judge Gilley, and had a great time doing that. But this is my first time for a keynote address. So I'm going to try to figure out how to share my screen. I've got some slides. Let's see here.
I will make you the host so that you can do that.
Okay.
How do I make you the host now? Just try to do that.
So as Ms. Lee was saying, I got to fill out the term, unexpired term of Judge Gwynn, and this next year will be running for a full term when all of our judges are up. A little bit about this court. General Sessions Division 3 was created in 2008, and there are about 35, I believe, General Sessions courts across the state that have probate jurisdiction, like this court does. Typically, conservatorships, are filed in Chancery Court or Circuit Court. However, by private act, this court was given probate jurisdiction. And so we're able to do that. And frankly, this year, there have been 54 conservatorships filed in General Sessions Division 3 and 2 conservatorships filed in Chancery Court. So we're quite busier here in Division 3 than, let's see, cap presentation. Well, there we go. Okay, if you all can see that now. No, I can't. All right, is that showing up?
Yes, it is.
Okay. So because there just really are not a whole lot of conservatorship cases that go up on appeal, I'm going to talk to you about a hodgepodge of things. So today I'd like to address some issues with filing conservatorship cases. These are things that the clerk's office has brought to my attention that we, I think, need to address with attorneys. I'll also talk a little bit about mandatory conservatorship training. I know Amy and Jennifer were talking about that, and I want to tell you, I'm give my full-throated support in that. And Amy and I spoke, I guess it's been about 2 or 3 months ago, about getting the general sessions judges who exercise probate jurisdiction on board with that. And I don't believe there's going to be any pushback. I think that that's something that everybody absolutely needs who's going to be doing this, particularly the non-lawyers. That's where we see most of the problems. Going to talk about a few cases, do a little bit of case law update. There's, as I said, there's just not a lot. I had to go back to January and April of last year to bring some cases in. Also, there was a case that came out in January of this year dealing with some fees. So, and then want to talk briefly about orders of protection in conservatorship cases. The statute, I believe, was changed in October of last year. Some changes went into effect regarding ways to protect vulnerable adults, and want to make sure everybody is aware that there is an avenue there through the order of protection statutes using the welfare statutes in Title 71 that enables a conservator, an attorney ad litem, a relative, others to go and seek relief and protection for a vulnerable adult. Let's see here. So some current issues. As of October of 2020, the clerk's office is required to provide some statistical data to the Department of Human Services as well as the FBI regarding the respondent when a conservatorship takes effect. And it's not complicated, but it's also, it includes information that might not typically appear in a petition for a conservatorship. So it's absolutely necessary that this get filled out and provided to the clerk's office because they have to turn it over to the state and the FBI within 3 days. And so this is something that it's new, so a lot of folks are not really used to doing it. And the clerk's office asked me if you have any open conservatorships in Wilson County that were filed after October of 2020, if you would make sure that this statistical sheet is filled out. I've included the Wilson County Clerk and Master's website there at the bottom of this slide. So you can go there. The sheet is on there with the probate forms. It's very easy to print out. And so it's something that it won't take very long to fill out as long as you have the information, but you're required to put the name and alias of the any aliases of the respondent, the date of birth, race, sex, and social security number of the respondent, but also include any hospital or if the individual is in a hospital or treatment facility. So this is something that's got to be required or got to be provided to the clerk's office upon the filing of the conservatorship. Conservatorship orders, we see this a lot of times that I know folks get in a hurry, but the orders must address bond, accountings, annual status reports, and the property management plan inventory. All of those have to be addressed according to the statute. Now, they can certainly be waived if the court does that, but the order must address it so that the clerks can put that information in the letters of conservatorship. Emergency conservatorships, you have to submit an order for an attorney ad litem, as you know, pursuant to Tennessee Code Annotated 34-1-132. It is required that the court, upon the filing of an emergency conservatorship, appoint an attorney ad litem. And we'll talk later about a case involving some attorney ad litem fees, which many of you are probably familiar with from Judge Kennedy's court last year. But that the order now, and I don't necessarily mind if the actual order for the emergency conservator actually has the information for the attorney ad litem in there or blank for the court to fill out, or if you want to do a separate order. That frankly, it doesn't matter to me as long as that information is in there on a separate order or the order for emergency conservatorship. The conservatorship order also must address whether the court is appointing or waiving a guardian ad litem. This is something that, in situations where we have a child who has now become an adult who is disabled, and we have a parent or parents who seek conservatorship over that child, the child has no income other than maybe some disability income, no significant assets or anything. In those situations, the court is likely to waive the requirement of guardian ad litem. It's just no need to incur that additional expense. And also make sure when a conservator non-attorney is being appointed, they understand the expectations regarding accountings. we see so many times people come in and they just dump a bunch of receipts on the clerks, and the clerks, they expect them to put this together for them. And that's not how it works. That's not fair to our clerks. That's not what their role is. They're supposed to go through and check and make sure that everything adds up, but they're not supposed to put it together. And we have, well, when I took office about 3 years ago, we had a situation. There were several conservatorships that were simply open but inactive. There's not been any activity for a year or two or even more. And I went to my clerks and we sat down and I said, we can't do this. This is where this creates situations where people can take advantage and steal money and do bad things. So what I had them do over that probably first 18 months of my tenure was go through every open conservatorship. And if there had not been any activity within probably 6 months, we show caused them in to court and asked, give us a status, what's going on. And we had a few who just ignored us. And so I, sua sponte, removed them and appointed an attorney to investigate and find out what was going on. And as recently as 2 weeks ago, we had an accounting due. And the lady showed up, brought some bank statements, some receipts, and said that she was not aware she was supposed to be doing an accounting. Nobody told her that, and she didn't want to do it anymore. She didn't want to be the conservator anymore. So we obliged, happily let her out. But, I can't stress enough how important it is. If accountings are required, make sure that the proposed conservator understands what that means, what they're going to have to do, because it can be very difficult. Now, if they put all the assets into one conservatorship account simply and pay things with a check instead of drawing out cash, it can be quite simple, or a debit card. But just make sure that the non-attorney conservators fully understand what they're getting themselves into when accountings are required. Regarding mandatory conservator training, as I said, I'm fully supportive of that. I think it's great. I want to brag and want to thank Michelle and Amy and everybody for allowing me to do this. I want to brag on Amy and her office a little bit. If you've not been to her website, I've got it listed right there. You really need to. She has put together such excellent training information, materials, videos, all kinds of, there's quizzes you can take. There's just a plethora of information. You could take somebody off the street who'd not ever heard the term conservator and put them through what she's got on the website, and they would fully understand what it would mean to be a conservator, be a fiduciary. And I can't brag on her enough. That website is just stellar. So what I'm planning to do, I understand the legislative committee is working and going to put that before the legislature. I hope that passes. Either way, we're updating our local rules, and I'm going to make it a requirement for particularly non-attorney conservators that they must go through the training before they are allowed to serve in that capacity. And I've debated on whether do we require the training be completed before they actually get their letters, or do we make it, give them 30 days from which the letters are issued in which to complete the training, and if they haven't provided proof, drag them back in. And I'm still on the fence on that. I'm not sure whether we should require it beforehand or give them a little bit of time to complete that training. And I'm certainly open to input from anybody regarding that if you have any. So let's talk about some cases. In re the conservatorship of Leyland Eugene Perry. This is a very, very interesting case. This came out of Chancery Court for Cannon County, Chancellor Wilson over there. This was published in January of 2020, but the conservatorship started, well, back in 2014. So in 2014, in February, Mr. Perry executed a warranty deed conveying 29 acres of land to his employer, Mr. Hollingsworth, for $15,000. Now, that on its face sounds kind of suspect, I'll grant it. But when you hear all the details, it doesn't really sound like that bad of a deal. So October of that same year, Mr. Perry's niece, Ms. Bush, filed a petition for conservatorship over Mr. Perry. Mr. Perry filed a statement with the court denying that he needed a conservator. In November, Ms. Bush moved to amend the petition to request that the sale of the property to Mr. Perry's employer be rescinded or set aside. And in her amended petition in November, Ms. Bush alleged that Mr. Hollingsworth had taken advantage of Mr. Perry's diminished mental capacity by purchasing the property at a price significantly below the market value. She further claimed that as a result of the sale, Mr. Perry was essentially homeless. Mr. Perry filed a response and he denied all the averments in the amended petition. On November 25th of that year, 2014, the trial court appointed a guardian ad litem to review Mr. Perry's medical records and to investigate and so forth, find out and report to the court. The guardian asked the court to appoint a psychologist or other appropriate professional to evaluate Mr. Perry, and the court agreed and did so. Mr. Perry met with Dr. Foster, and Dr. Foster's report was filed in October of 2015, the following year. Thereafter, Ms. Bush wanted to get out. She didn't want to be the conservator, and she asked the court to appoint a cousin of Mr. Perry in her stead. She was his niece. They had a trial in August of 2017, and the court ruled that Mr. Perry suffered from a mental disability. It was in need of partial conservator as contemplated by Tennessee Code Annotated 34-1-126. In its memorandum order, the trial court relied in large part on the findings of the guardian ad litem and Dr. Foster, that Mr. Perry did not need a conservator for daily living, but would need a partial conservator to make decisions regarding his property. Accordingly, the court established a partial conservatorship for the care of Mr. Perry's property. The trial court, a motion to alter and amend was filed in November of 2017. And after reconsidering the evidence presented at trial, the trial court on its own motion amended its September 29th order determining, quote, that there is simply not enough proof indicating that Mr. Perry is in need of a conservator for either his person or his property under Tennessee Code Annotated 34-3-101. So he was in need of partial conservatorship to manage his property. He can handle his day-to-day living. Here, the court reviewed it and said, you know, I don't believe that's correct. I think that Mr. Perry is okay. The court based its decision on finding that Mr. Perry has the necessary ability to conduct activities of daily living, live on his own, drive, and even maintain regular employment with Mr. Hollingsworth. And regarding the sale of the property, the court determined that Mr. Perry seemed pleased with the transaction, as he received a promise from Mr. Hollingsworth that he would be permitted to live on the property for the rest of his life. This was later formalized as a life estate conveyed to Mr. Perry in October of 2016. And the testimony at trial was that Mr. Hollingsworth and Mr. Perry, neither one of them knew that you could do a life estate. They didn't consult an attorney. They didn't go to anybody when they made their deal. They did a handshake deal. And in addition to the $15,000 purchase price, the deal included a Kubota tractor and a late model Dodge pickup truck. And Mr. Perry received the promise from Mr. Hollingsworth that he was going to renovate his family home. There was a dilapidated home on this 29-acre farm, and it had no running water, had no heat or air. It was just an old fallen down farmhouse. And Mr. Hollingsworth estimated it was going to cost about $50,000 to renovate the home. So ultimately, Mr. Perry's deal was not for $15,000, just $15,000. It included the tractor they valued at $15,000 to $20,000, plus the pickup truck that was valued at $10,000, and the value of the life estate to a renovated property. So the court determined such an arrangement certainly appears to be the byproduct of Mr. Perry's own thoughtful planning and is evidence that he does not need a conservator to manage his affairs. The appellate court reviewed the petition for appointment of conservator requires a lower court to find, quote, by clear and convincing evidence that the respondent is fully and partially disabled and that the respondent is in need of assistance from the court. That's 34-1-126. So the dispositive issue on appeal was whether the trial court erred in determining that Mr. Perry did not need a conservator. His cousin, Mr. Bush, appealed the trial court's decision after the motion to alter and amend. And the appellate court does a kind of a short discussion about what it means to need a conservator and so forth. And they said the fact that an individual is found to have a disability does not automatically lead to the conclusion that he or she will need a conservator. A respondent's need for a conservator depends upon his or her capacity to perform necessary tasks, a capacity which may or may not be affected by the respondent's disability. And they discuss capacity really encompasses two concepts or two ideas: functional capacity and then decision-making capacity. So functional capacity, which is not at issue regarding Mr. Perry, relates to a person's ability to perform routine daily tasks, such as feeding and dressing. Decision-making capacity, on the other hand, which was at issue here, involves a person's ability to, one, take in and understand information, and two, to process the information in accordance with his or her own personal values and goals, three, to make a decision based on the information, and four, to communicate the decision. So persons really have different abilities, levels of decision-making. A person may be simultaneously capable and incapable with respect to different types of decisions. Courts routinely apply different standards for determining capacity depending on the nature of the decision or action involved. Accordingly, capacity should be determined on a decision-specific basis. Here, Dr. Foster had determined that although Mr. Perry had some impairment with regard to his executive functioning, the impairment did not represent a significant detriment to his basic daily functioning and decision-making capacity. Dr. Foster concluded that Mr. Perry will likely experience greater difficulty in making decisions that require memory for facts or previous events, manipulation of information that are based on multiple subcomponents, and that involve more extensive processing of information. However, his capacity to make financial decisions, while diminished, resulting in the patient being at risk for being taken advantage of and making poor decisions, doesn't mean that he made a poor decision here. And his capacity to make financial decisions is not diminished to the extent such that he cannot live independently. That was Dr. Foster's report. And so the Court of Appeals said, thus, Mr. Perry would only need a conservator if his circumstances required him to make complex financial decisions. Mr. Perry testified at trial that he was 43 years old. He had a driver's license and a full-time job working for Mr. Hollingsworth. And this is the rationale for the Court of Appeals upholding the trial court's decision. Mr. Perry said that he assisted Mr. Hollingsworth with farm chores for $10 an hour, a job he had held for over 20 years, and he lived on one of Mr. Hollingsworth's properties rent-free. Mr. Perry explained that when his father died, he inherited the 29-acre tract containing his childhood home, but the home had no heating, air, or running water. According to Mr. Perry, he didn't have the money to fix it up, and he had a lifetime to live in it anyway. So his rationale was, look, I can't afford $10 an hour to put $50,000 into an old dilapidated farmhouse, but my boss is willing to do this and allow me to live in it the rest of my life. And I see, since I've got control of this thing, that I'm admitting people here and there, so I apologize if I get off track. Mr. Perry had also testified that he and Mr. Hollingsworth entered into an agreement whereby Mr. Hollingsworth would purchase the property in exchange for $16,000. The deed said 15. They both, Mr. Hollingsworth and Mr. Perry, the grantor and the grantee, both said that they intended that to be $16,000, and that's what actually transpired. So there was a typographical error, evidently, or scrivener's error in the deed itself. Mr. Perry also testified that as part of the agreement, Mr. Hollingsworth would renovate Mr. Perry's childhood home and allow him to live in it for the rest of his life. So the court is saying that Mr. Perry actually contemplated several different aspects of this agreement and came to the conclusion that it was to his benefit. So by that reasoning, and the trial court used that reasoning, that Mr. Perry might have some disabilities, some mental disability here, but he still made a reasoned, rational decision And so he didn't just give away 29 acres for $15,000. He actually contemplated all of these aspects of the deal to make this decision. So the Court of Appeals said, while Mr. Bush, the cousin, asserts that Mr. Perry's decision to sell the property was unwise, the court ruled a person does not lack decision-making capacity merely because he or she does things that others either do not understand or find disagreeable. We have a situation here before the probate court wherein an elderly couple, the wife is in an assisted living facility and she is incapacitated completely. The husband was living at their marital home, a very, very nice home, acreage, very fine horse barn, and they were very successful during their marriage. But the husband, unfortunately, started making investments in Iraqi dinar, and I believe the currency in Nigeria, and I'm not sure what that is. But many of you may know that those currencies don't appreciate. It's not like buying gold. And we had a situation where the assisted living bills were not getting paid. And the assisted living facility, I think, was owed some $35,000, $40,000. And it was a very sad situation. But here, to compare it to Mr. Perry's case, the husband in this one was making not rational decisions, and to his and his wife's detriment. He thought he was making wise investments, but it turns out he was wasting their money and not paying the bills for her. I believe that there may have been a small HELOC mortgage on the house, but it wasn't as far behind as the assisted living facility. But we ended up having to sell that property, and they got a very good price for it, enough to make sure that they're both comfortable for the rest of their lives. But a very sad situation. But in the Perry case, the trial court, Chancellor Wilson and the Court of Appeals determined that might have looked on its face like a really bad deal, but it turns out it wasn't. It turns out that Mr. Perry had made a rational decision, and contemplating all those factors, decided that was a good deal. So interesting case. It's not very long, so I'd recommend reading that one. And I don't know if it was published or not. I printed it off the AOC website, so I don't have a Southwest citation for you, but I can get you, if anybody needs it, certainly email me and I can get you the Court of Appeals middle section number for that if you would like. The next case I'd like to talk about is in re the conservatorship of Daniel Allen. And here, I mentioned this earlier in my remarks, but this is a case out of Judge Kennedy's court in Davidson County. And it was a situation where first, the Department of Human Services filed a petition. Shortly thereafter, the facility where the respondent was residing or being cared for filed a second petition. The court ultimately appointed guardian ad litem. The guardian ad litem determined, in talking with Mr. Allen, that he was going to contest the conservatorship, although he probably needed it, but he was going to contest it. And therefore, Judge Kennedy appointed Mr. Sandoval as Mr. Allen's attorney ad litem. And so through natural progression of the case, it came down to the issue of who would be responsible, the state or the facility or Mr. Allen, for the attorney ad litem's fees. And the court, Judge Kennedy, ruled that pursuant to Tennessee Code Annotated 34-1-125B, that it didn't have discretion to waive the provisions in that statute. Therefore, the attorney ad litem fees had to be charged to the respondent, Mr. Allen. That issue went up to the Court of Appeals. Mr. Sandoval and LP North determined that they wanted to appeal. And two issues were brought up: whether the court had discretion to waive, pursuant to 34-1-121A, the requirement under 34-1-125B that the respondent pay the attorney ad litem fees. Also, Mr. Sandoval raised the issue of whether attorney ad litem fees were recoverable under Tennessee Code Annotated 2012-119A.